In this third video on the Texas Family Law Foundation Betrayal of Trust, from this article in 1964 by William Morrow, what he's really looking at is what did the state of Texas try to do to help solve the problem of divorce. So the State Bar of Texas created a family law section to survey the problem of family legislation. The major project of the section has been a study of the Model Family Court Act as promulgated by the National Probation and Parole Association. At the 1963 State Bar meeting in Dallas, the section recommended to its membership proposed legislation creating a statewide system of family courts. The family courts, as envisioned by this section, would replace the present special courts of domestic relations in the larger communities and would have jurisdiction over all family matters. Such courts would have the dignity and compensation of district courts. Dignity in family courts, that was a nice pipe dream. Today, I think that there are very few people who associate dignity with family courts, but this is what they wanted to do. They wanted this family court to have some type of dignity and respect. On January the 1st, 1963, after several months of public hearings, the Interim Study Committee on Divorce in the Texas Legislature reported its findings and recommendations. And by the way, this committee, back in 1963, viewed divorce as the #1 social problem of our day. The committee recommended a family court system. In lieu of the existing courts of domestic relations, they recommended the creation of child welfare agencies to assist the courts. I don't know if this is CPS or not, but I mean, that is another wonderful organization that just brings fondness and affection from the hearts of many people. Requisite appearance of the defendant in divorce cases where children are involved. Requisite appointment of an attorney ad litem to represent the children of divorce. Again, this is another person in the court system that rapes you financially, purportedly representing the children. If they were representing the children, they should be telling mother and father, stop the divorce, reconcile, get things right, because if you don't, you're going to be destroying your children. I have not really heard of any attorney ad litems doing that. Now, if there are some, and you know of some, please shoot me an email or write their name under the comments here. And they also recommended increasing the waiting period from 60 days to 90 days, and the abolishment of common law marriages and other minor items. William Morrow says, it is only a beginning. It is hoped that the State Bar's Family Law section will at some future time recommend to the Texas legislature enactment of a comprehensive measure that will provide our state with just and wholesome laws on family disorganization. That seems to be a contradiction. He wants the state to have just and wholesome laws on family destruction, because divorce is family destruction. And he says certainly the section as a respected adjunct of the State Bar of Texas, I don't know who respects these people these days, has an invaluable opportunity to impress upon the legislature the barren inadequacy of our present laws and the pressing urgency for reform. Now, William Morrow looks outside of Texas, and he talks about some other states as well. Most aspects of this nation's family laws are completely out of touch with the realities of modern divorce. If they were out of touch back then, they're really out of touch today in 2018. He does mention some other states that had some occasional successful experiments that are well worth examining and perhaps emulating by our own legislature. Now, in California, for example, the statutes of the state provided extensive conciliation procedures which may be invoked by either spouse. So if you were going through a divorce and you did not want the divorce, you could ask for, demand some type of procedures to possibly save the marriage. That was something that you could invoke. Either spouse could invoke this right. today, the Texas Family Law Foundation is opposed to such things. The Texas Family Law Foundation and their attorneys do not make money if the couples reconcile. They only make money if the couples divorce, and if they can get a good conflict going at the same time, and if they can destroy the kids and the family and everything, just completely destroy this. This is what the Texas Family Law Foundation wants. However, back in the 1960s, California tried something, and it was an extensive conciliation program. An ambitious experiment along these lines resulted in the establishment of the famed Los Angeles Children's Court of Conciliation. A unique feature of this system is the provision for a formal conciliation agreement which, with the consent of the parties, may be reduced to writing and made an enforceable order by the court. And he says this: the court has claimed an impressive record of success. A 1959 report showed that for the preceding 5 years, the conciliation court had been able to reconcile 43% of the couples. 43% of the couples willing to listen to professional marriage counselors, and 3/4 of those couples who reconciled were reconciled permanently. What is so unreasonable about this that the Texas Family Law Foundation and modern-day divorce attorneys in Texas oppose such a suggestion as this? This is why I say that the Texas Family Law Foundation is guilty of a betrayal of trust. These attorneys, these divorce attorneys, these people at the Texas Family Law Foundation know there are studies, there are testimonies of judges, there are testimonies of family therapists that have said that at least 40% of the divorces are what they call needless divorces. However, divorce attorneys don't make money over needless divorces that reconcile. They only make money if the needless divorces become a divorce. They are willing to destroy families and marriages and children in order to make money. How perverse. So this was the state of California. And by the way, the state of California was the first state that came up with the no-fault divorce laws. What people don't realize is when no-fault divorce came out, no-fault divorce was not to create a system of divorce on demand. No-fault divorce was designed to help reconcile families. And they had this track record where 43% of the people who were willing to go through this process reconciled 75% of them permanently. However, after passing the no-fault divorce, and this was supposed to accompany it, this court of reconciliation, they chose not to fund that. So they created a system of divorce on demand. By the way, the man who really was a driving force behind divorce on demand, I believe his name was Representative Jim Hayes. After he was pushing for this legislation because he wanted to divorce his wife and move on to somebody else. Well, within 5 years after he got his no-fault divorce, the no-fault divorce worked in his favor. He got to keep a lot of his assets. His wife was on food stamps. No-fault divorce. It doesn't hurt anybody. I mean, this is what we need in our country, right? Is more no-fault divorce? No. Back in the 1960s, California said we need to have a system set up to help reconcile marriages, and it worked. Why is the Texas Family Law Foundation against that today? Is there something special about destroying families, or is it better to save families? In Wisconsin, they had a code that was drafted, and the code was drafted with the help of clergy, sociologists, and lawyers. Now, I think this is a very interesting mix because attorneys often claim like they are sociologists. Somehow, they are also your spiritual advisors. Moreover, they are child psychologists. They lie to you about these things. They are attorneys who make money off of destroying your family. But instead here you had a code that was drafted with several different people from different occupations, different backgrounds, people who actually help to save families rather than just make money off of destroying families, the state of Wisconsin came up with this code. And the code provides a family court system and imposes a duty. This was a duty on the courts to cause an effort to be made to reconcile the parties. How nice that would be in Texas if we had a judge who would actually say, you know what, I don't believe in this divorce. I am going to make you two people reconcile. However, I've talked with conservative judges, and these conservative judges hide behind the excuse, we can't make law from the bench. We are obligated to grant a divorce if somebody claims insupportability. In other words, a judge cannot act as a judge. The judge acts as an enforcer of the law. And I thought the enforcers of the law were policemen, not judges. I thought judges were supposed to be able to come to a decision based on guilt and innocence. But in Texas, guilt and innocence mean nothing. All that matters is if one person files for divorce, that person wins 100% of the time. It would be nice if the courts had a duty to make people try to reconcile. The state of Ohio also made great progress in family law matters through the use of the family court system. So the family court system was not always bad, as it is today. We're short-sighted if we think that the family court system was just a horrendous mess the entire time, as it is today. And people who live in the family court system in the year 2018 understand that the family court system is a horrendous mess. It is a disaster. It is a train wreck that has occurred and is continuing to occur on a daily basis. But it wasn't always that way. The state of Ohio made great progress in family law matters through the use of the family court system. The statutes provided the courts the power to conduct an investigation into the background of the parties and circumstances of a contemplated divorce. Such authority had been utilized to provide competent professional staffs to assist the courts in the sociological aspects of family problems. In other words, they were helping marriages that were sick stay together. They were not killing every sick marriage like the divorce attorneys in the state of Texas do. The reality of irreconcilable differences, Mr. Morrow continues, between spouses has been recognized by the states of New Mexico and Oklahoma through inclusion of incompatibility as a statutory ground for divorce. What actually is incompatibility? Is incompatibility that my wife is not happy that I'm having an affair? Is incompatibility the fact that I have met a man who has more money than my husband and he is not happy with that? Maybe that's incompatibility. There is no definition of what incompatibility is, but it has now become a statutory ground for divorce. In the state of Texas, it has actually become a legislative ground for divorce. Divorce must be mandated by judges legislatively. This whole idea that you're going to go to a family court and find justice, you need to disabuse yourself of that notion. It is not the case. Family courts are the place where you go to get your families destroyed. For any reason, for no reason, the family court will always work for the destruction of the family by the person who wants to destroy the family. That's just the way it is. So the idea in New Mexico and Oklahoma at the time was to remove all concepts of fault or guilt from matrimonial litigation. Litigation? The interesting thing about matrimonial litigation is that the reluctantly divorced spouse often has to pay financially for something that he or she can never win. And that is the absurdity and the perversity of the entire thing. Such non-fault grounds, however, are but a futile gesture. And this is something that he recognized. The idea of no-fault divorce are a futile gesture toward reform unless accompanied by measures providing assistance and advice for distressed couples whose differences are not irreconcilable. Wow. A person who says just because a person says that things are insupportable may not be telling the truth. You could look in these irreconcilable differences and find out that the differences aren't irreconcilable. In fact, the interesting thing is that about 6 to 8% of the people who get divorced under irreconcilable differences remarry each other. And in fact, in the state of Texas, if you get divorced, you have to wait a certain number of days, I believe it's 30 days, before you can marry somebody else. However, you can marry your spouse 2 days, 1 day, 3 days, 8 days after you get divorced, based on irreconcilable differences. Irreconcilable differences has no meaning in law. If irreconcilable differences were really irreconcilable, why does the state of Texas permit people to remarry each other within 30 days? That's the only person you can remarry that you can marry within 30 days. The state of Texas is completely inconsistent in this. And honest attorneys, honest people back in the 1960s realized that irreconcilable differences were not necessarily irreconcilable, and they realized that people commit perjury in family courts as they do today, but they actually took a stand against it. Thank you.